Welcome back to Good Law, Bad Law. My guest on today's episode is a returning friend of the program, Steve Vladeck, who is a constitutional law professor at the University of Texas School of Law. And we're talking about the shadow docket of the Supreme Court. We often scrutinize and study so carefully the rulings of the Supreme Court, the opinions, the reasonings and arguments in Supreme Court opinions, and even down to which justices voted which way, especially on highly impactful decisions of the Supreme Court. But increasingly, and more so in the era of President Trump and his Justice Department than we've seen ever before in American history, the use of the Supreme Court making important decisions without opinion, without a vote count, without letting the public know which justices voted which way. And this is deeply concerning, much as many critics have voiced concerns about the rise of executive orders. According to Steve, much of this may be traced to the abdication of Congress's responsibility, and to fully understand why that is and why these types of rulings from the Supreme Court, which again we're seeing with increased frequency in in recent years, and may indeed pose a threat to some of the Biden administration's initiatives. You have to listen to this episode and to have Steve Vladeck explain why. So everybody keep safe. I hope everybody's getting vaccinated or certainly getting appointments now that there's a very decent supply of vaccines that we're seeing in states across the country. Everybody get vaccinated, please, for yourself, for your families, and for the rest of us as well. And stay tuned for my conversation with Steve Vladeck on this episode of Good Law, Bad Law. I want to welcome back to Good Law, Bad Law, Steve Vladeck. Steve is a law professor at the University of Texas School of Law. Steve, thanks so much for being back on Good Law, Bad Law. I appreciate it.
Happy to be back.
So, Steve, we wanted to talk to you. There was an article recently in Reuters that really caught my attention, and you were quoted in the article, so I figured you would be the right person to go to try to understand this a little bit better, involving the Supreme Court and its so-called shadow docket. I really liked the idea of talking about this because most of the time when people who are not constitutional law experts like you think about the Supreme Court, it's the big high-profile stories. Late last year, it was, is the Supreme Court going to get involved in former President Trump's kind of wacky, scary insurrectionist theories about how he really won the election. This is the kind of activity the Supreme Court engages in that most people don't know anything about. So help us understand it. When we think about the shadow docket at the U.S. Supreme Court, what actually is that?
Well, I mean, I think the first thing to say is it's no one thing. It's actually an amalgamation of a bunch of different data points. But basically, like any court, the Supreme Court does a whole bunch of stuff other than hand down lengthy, signed, reasoned opinions in the high-profile cases that we're used to, seeing each spring. And most of that stuff is anodyne. I mean, most of that stuff is deciding which cases to take up. It's, granting procedural extensions. But what we've seen a real uptick in recent years is using those orders, using these unsigned, often unexplained orders to actually change the status quo in litigation. And so that can mean, putting on hold a lower court decision while the party that lost appealed. It could mean when a lower court refused to block a state or federal policy, the Supreme Court blocking it on its own while the appeal is pending. It could mean, as we saw a bunch of times last fall, when a lower court blocks the scheduled execution of someone on death row, the Supreme Court, vacating that and clearing the way for the execution. And, the real, what I think are especially dramatic is that since 2018, we've seen a lot more of these orders where the court has changed the status quo and has not necessarily explained why or why it needed to do so through its, extraordinary, unusual orders list as opposed to through a regular opinion.
Well, and the example that you mentioned about, stopping or not stopping an execution, that's really where I kind of thought we were going to go with this, because those kinds of decisions from the Supreme Court often don't actually involve all of the justices. Those are things that oftentimes are decided by one justice on the Supreme Court ultimately, for practical purposes. What are some of the other impactful kinds of shadow docket type decisions that we've seen recently that are good for us to understand, do you think?
I mean, I think, in February alone, the Supreme Court had a series of orders where it basically blocked state and local regulations in California that were limiting indoor religious services in light of COVID. So there was a decision late on a Friday night in early February where the court blocked the statewide restrictions on indoor religious services. And then a couple weeks later, the court blocked Santa Clara County's restrictions, even though Santa Clara County had gone to great lengths to explain why its restrictions were not as problematic as the state's. And, in both of those cases, the lower courts had refused to block the restrictions. The churches were getting ready to appeal, and the Supreme Court reached out to, block those restrictions by itself without any majority opinion, without any explanation as to what exactly was problematic about what first the state and then Santa Clara County had actually, attempted to do in balancing, folks' right to religious exercise with the need to sort of protect public health during the COVID pandemic. And so, that's where we've seen a real uptick, where the court is actually the first actor to allow something to either go into effect or to be put on hold when the lower courts have refused to do so. And again, that's problematic enough in the abstract, but we have no idea why, because there's no majority opinion from the court explaining what exactly the infirmity was.
Well, so how is a ruling like that, Steve, different from when the Supreme Court simply declines to accept an appeal from a lower appeals court, and by not acting or by deciding not to take the case, it keeps in place what the lower appeal court rules? How is this different?
It's the exact opposite. So, in the context where the Supreme Court declines to exercise its discretion to hear an appeal, nothing is happening to the status quo. Whoever won in the lower court wins. Yeah. And if the result of the lower court decision was that a policy is blocked or a policy is upheld, that's the result. Here, in contrast, it's exactly the opposite, where the Supreme Court is basically taking whatever the status quo was, reversing it, and not telling anybody why. So not telling lower courts what they did wrong, not telling local and state officials what they should do right next time. And so, I think there are sort of multiple levels of problems with these kinds of rulings. The first and foremost of which is just their inscrutability, where if the court is going to change the status quo, it seems incumbent upon however many justices are in the majority, and we often have no idea because they don't tell us the vote count. I think it's incumbent upon them to actually provide at least some modicum of explanation as to why.
And what is the reason that doesn't happen, or what is the? Well, I guess that's the first question, and then the second or related question is, what is the constitutional authority for the Supreme Court to decide an issue in this way?
Well, so to the first question, I think this is where the sort of the blurring of the lines between the court's orders and its opinions is really important. Historically, the norm is that the Supreme Court does not explain orders. So if the justices vote to deny certiorari to decline to take up a case, they almost never explain why, and they almost never tell us why. If they vote on something more anodyne, like giving a party more time to file a brief, we don't usually get the vote count. There's a tradition that an order from the Supreme Court, as opposed to an opinion, is accompanied by neither an opinion of the court nor a vote count. But that tradition, I think, is largely sort of tied to the assumption that those orders are, as we said, pretty banal, that they're not actually dramatically upsetting the apple cart, that, at most they're either leaving in place what was true below, or they're promising further review, for example, if the court grants cert. And so as we see more and more of these orders that are having more significant and substantive and status quo altering effects, that's where the tradition of not explaining them and of not releasing the vote count looks increasingly problematic. As for constitutional authority, nothing in the Constitution requires the Supreme Court to explain itself. I think, we like that it does, but the actual practice of the court speaking with one voice wasn't really the court's practice for at least the first decade that it existed. It really wasn't until John Marshall became Chief Justice in 1801 that the court started actually trying to speak with one voice. So, I don't think that the argument is that the Constitution requires the court to issue an opinion for the court, or that it requires the justices to give us a vote count. I just think that it's best practices, because otherwise it's increasingly difficult to understand what the court is doing and why. And for as problematic as that is for court watchers like us, imagine being a lower court judge trying to parse out what they're supposed to do in the next case, or imagine being an executive official in another state trying to figure out, after the California cases, what they are and are not allowed to do with regard to restricting indoor religious services. So, I think it's not a formal constitutional problem. It's just that this is an awkward way for the Supreme Court to be dispensing its form of justice.
Well, and that's what occurs to me as I'm listening to you explain it too. Is that I don't know that the Supreme Court has ever said so in so many words, but the reason the ultimate authority on the Constitution, the Supreme Court, does write opinions is to offer guidance to other judges sitting in other courts as to how they should, what the law is and what the Constitution means on a particular issue. If they don't issue an opinion explaining themselves and don't even let you know what the vote count is, and which justice has voted which way, there's really no guidance that can be taken from any of these types of decisions. So why do you think this is happening, and why is it happening more and more now? Is this about Chief Justice Roberts? Is it something about the politics of our time, or what do you think is really going on to explain this?
Well, I think that's a longer and harder conversation. I think it's the confluence of a series of trend lines that have all been pointing in this direction for some time. But I think the moment where the brakes, I think, really seemed to come off was Justice Kennedy's departure at the end of in the summer of 2018. Because it's not that Justice Kavanaugh is some procedural radical. I don't think that's what happened. I think it's that with the departure of Justice Kennedy, there was no longer a need for either sort of side of the court's political wing to moderate itself. That, trying to sort of keep Kennedy on side was no longer a concern. And so we started seeing sort of more efforts to take procedural shortcuts in cases where they were available. And so just, to sort of, not to try to point out, but I think part of what the court is doing increasingly is it's using these orders to issue what are effectively merits rulings, where it's not just sort of about altering the status quo pending appeal, but where they're basically saying, guys, we think the law should be X, and so we see no reason to wait 2 years to say so. And that's all well and good, but there are reasons why that's not how the court usually operates. And if that really is their view, if their view is that we want to say now that this thing that's happening is good or bad, they should actually say so. And to me, the most egregious example, again, going back to the California cases, in the Santa Clara County case, a couple of weeks after the court had struck down the statewide restrictions on indoor religious services, the court not only does the same thing with Santa Clara County, but it chastises the Ninth Circuit for refusing to follow the earlier decision, an earlier decision that had no opinion. And so
Right.
there's this
Wow.
increasingly alarming disconnect between what the justices who know internally why they're voting the way they are, and all the rest of us who are left to guess.
I have to say, Steve, this is actually a lot scarier to me, and frankly a lot more anti-democratic than I appreciated. There's a kind of parallel, not a perfect analogy, but a parallel in the rise of executive action. That there's been a lot of conversation about through a lot of presidential administrations. You can talk about congressional gridlock being an explanation for that and all. But even with executive action, and we saw Biden come in and overrule a lot of Trump's executive orders. Trump came in and overruled a lot of Obama executive orders. But at least there was transparency. You knew what was happening, and you knew why. Here the Supreme Court is taking action that does have significant impact, whether it's public health, public policy, individual rights and liberties, religious. I mean, it's very impactful decision, almost completely in the dark, or leaving us in the dark, really, making these rulings in secret. I find that really striking.
Yeah, I mean, I think it's a real problem, and I think to me one of the most intriguing things about it is at least thus far only one of the justices has been really vocal in criticizing this, and that's Justice Sotomayor. She's penned a series of dissenting opinions, dissenting from a bunch of these orders, saying like, hey guys, this is no way to run a railroad. I mean, even the Roman Catholic Diocese case from November, the New York case about the New York religious worship restrictions. The dissents in that case from the progressive justices were principally on the merits, and not about the sort of the impropriety of deciding such major questions in such a stilted, truncated form. And I guess, this is my broader concern, is that some folks look at this and say, well, as long as they're getting the right answer, who cares? Like if the court's reaching the right result, why do we care whether they're issuing a 50-page opinion or not? And I think that's the wrong way to look at this. It's just the trend line of the Supreme Court increasingly issuing status quo decisions with no reasoning is something that should bother even people who like the outcome, because it's increasingly sort of subverting what we think of as what the Supreme Court's role actually is supposed to be in our system. And it's possible that this too shall pass, that this is a reaction to a series of unique overlapping events, the election, the pandemic, the reinstitution of the federal death penalty last year. But, I guess I'm not quite as sanguine that this is a passing fad as opposed to an increasing sign of the new normal. And I think there are reasons to be genuinely concerned about this as the new normal, even if, people might actually like the individual results of the individual orders in these cases.
Well, yeah, but I mean, the problem with that is the same problem with, when you look at the politics that goes on in Congress. You can say, well, I don't like what the Senate Majority Leader, Phil Schumer or McConnell, is doing procedurally, but I like what they're getting done with that. Well, at some point, the majority finds itself in the minority. That's just going to happen. That's what happens. And so you can like it today, and then tomorrow you're not going to like it because suddenly you don't like the result. It seems very partisan when we're talking that way about the way the Supreme Court justices do their job, and very, very short-sightedly political when we're talking about the Supreme Court.
Well, and I think worse than that. I mean, it's folks are going to be sort of have different degrees of cynicism about the Supreme Court, and that's inevitable.
Yeah.
One of the best defenses that the court has to cynicism is rationed explanation, right? For the countless Americans who think the court is just a hopelessly captured political institution, one of the best rejoinders is for the court to write opinions that actually put out legal analysis that explain why it's reaching the result it's reaching, as opposed to just we were appointed by Republican presidents and they were appointed by Democratic presidents. And so, I think the worst part of all of this is that the more that the court does this, the more that the court is actually undermining its own ability to defend itself from charges of judicial activism, of partisan bias, and of the kinds of attacks that really do, I think, in the long run, inure to the detriment of the court's legitimacy.
Steve, are we seeing this? I mean, you mentioned several of these COVID cases where public health policy clashes with claims of religious liberty. Are there other areas of constitutional tension where we're seeing these types of or decisions being handed down in this matter?
I mean, I think we saw a number of decisions like this during the Trump administration, where lower courts blocked Trump administration policies, especially in immigration law, for example, and the Supreme Court, issued an unexplained, unsigned stay of that decision, where the external justification was we're going to allow the policy to go into effect until we can review it on appeal. But in reality, the appeals never got there, right? The policies either changed or Trump lost before those cases ever got to the Supreme Court. So, we saw a number of times in the Trump administration where the Supreme Court stepped in to allow these controversial policies to go into effect. And just to give you a bit of a data comparison, over the prior 16 years before the Trump administration, so the Bush 43 and Obama administrations, two very different presidencies, and two-term presidents, the same length. The Justice Department across 16 years only asked the Supreme Court for this kind of emergency relief, for a stay, in 8 cases, so one every other year. And the court granted 4 and denied 4, right? So, about what you might expect. In the 4 years of the Trump administration, in comparison, the Trump administration asked for such relief 41 times, and the court granted it in full or in part 28 times. So, we've seen a really dramatic uptick in those kinds of orders as well, in context in which the court has allowed controversial policies to go into effect pending appeal, in context in which the court has blocked policies that lower courts have refused to block pending appeal. And, that to me is the real sort of shift in the last 3 or 4 years, which is we've always had a shadow docket. As long as there's been a Supreme Court, there have been unsigned orders that mostly just dispense with procedural issues. It's how those orders are having increasing substantive effects in the last couple of years. That's really, I think, why the shadow docket has become such a much more important part of the court's work.
Well, what is your understanding, or maybe it's a prediction at this point, as to how the Biden Justice Department may act differently, or is the Biden Justice Department going to ask for this type of intervention by the Supreme Court as often as the Trump Justice Department did? Because now it's being done, so we're going to do it too? Or do you expect you'll see a pulling back on this, at least in terms of when the Justice Department asks for this type of intervention?
Yeah, I mean, I think it'll be the reverse, where I think actually the Biden administration's on the other side, because, again, I think this is where the ideology of the justices is doing a lot of work. I mean, one of the most important shadow docket rulings from the Obama administration was when the Clean Power Plan was upheld by the D.C. Circuit, the Federal Appeals Court in Washington, and it was the challengers who convinced the majority of the Supreme Court by a 5-4 vote to stay that decision pending appeal. So, I think that's what we're in for, where we see cases where, people challenging Biden administration policies are the ones now using the shadow docket. And, we already have one example. I mean, Ken Paxton, the Attorney General here in Texas, has an application pending in the Supreme Court right now, trying to ask the justices to allow him and a bunch of other states to intervene in challenges to the so-called public charge rule, because the Biden administration is no longer defending it. And so, I think the shadow docket's here to stay. I think it's going to be much more about thwarting the federal government over the next couple of years than the prior couple of years when it was much more about, blocking challenges to controversial federal policies.
Is there any check on this, either or theoretical check on this from Congress or from the executive branch? In other words, is there a way, if Congress decided to, that they could pass legislation to curb this on the part of the Supreme Court, or is the Supreme Court entirely free to continue this way of handling certain decisions if it chooses to, as a matter of its own internal operation?
I think the short answer is somewhere in between. I mean, the reality is that most of what the Supreme Court is doing is an exercise of its appellate jurisdiction. And constitutionally and historically, Congress has a pretty broad base of power to regulate the Supreme Court's appellate jurisdiction. So, I think if we're just going on historical terms, there's a heck of a lot Congress can do. I don't think Congress can stop the Supreme Court from issuing some of these rulings. I don't think that Congress could say you must provide X number of pages of reasoning or you must publicize the vote count. But I do think Congress could actually make it harder for the court to, overturn the status quo pending appeal. I think part of the problem is that Congress has largely gotten out of the business of doing that. I mean, the sort of since 1988, Congress has basically left the Supreme Court to its own devices when it comes to control of its docket. And, as there are these sort of broader conversations happening about court reform, the sort of conservatives think that's just a euphemism for expanding the size of the Supreme Court. It's not. I actually think one of the real areas where court reform is sorely needed is Congress reasserting some control over the Supreme Court's docket, because what we've seen over the 33 years since 1988 is that the justices, if left to their own devices, are going to adopt policies and practices that are probably inconsistent with what we think is what they ought to be doing. Just take one example. When Congress gave the court just about full control over its docket in 1988, the court was still hearing about 150 merits cases each term. That number is down into the 60s. Last term the court heard 53 cases. That was the lowest total since the Civil War. And some of that was COVID, but they're only on track this term to hear 56 or 57. That'd be the second lowest total since the Civil War. So, I think that this is, the shadow docket to me is both a problem unto itself and a symptom of a much broader disease where Congress has, abdicated its role in sort of an inter branch conversation, not about how the court should be ruling in any particular cases, but rather about the sort of more generally how the court's docket should be structured.
Well, I think Congress's abdication of its responsibilities is also, at least in significant part, but explains the rise of executive actions, executive orders. So,
I think the analogy there is quite strong.
Yeah, but this is one that I think most people, I certainly didn't know about, and I'm a lawyer and I tried to keep up with these kinds of things, but I really didn't understand this. So, something we're going to have to pay much closer attention to, and I've learned so much just in this conversation. So I really appreciate it, Steve. Thank you so much for being on the podcast. Steve Vladeck, everyone, from University of Texas Law School, helping us understand the Supreme Court's shadow docket, what it really means, and why it's something we all ought to be concerned about, I think. Steve, thank you so much. I really appreciate it.
My pleasure. Thanks for having me.